Are in Portland. I am also a law duck, having graduated from the U of O in 1982. Some of my classmates are here today. Judge DeVore, hello. Our third session today will be Professor Garrett Epps providing a preview of the coming U.S. Supreme Court term and what we might expect from the court's rulings during that term. As you know, the new term will begin the first Monday in October, which is just 4 days from now. Professor Epps is a professor of practice here at Oregon Law, having returned to the law school after serving as a professor at the University of Baltimore Law School from 2008 to 2021. Before leaving for the East Coast, Professor Epps taught constitutional law at Oregon for 16 years. He also clerked for the U.S. Fourth Circuit Court of Appeals. He received his JD and his LLM from Duke University. He was first in his class there, and attended Harvard undergraduate, where he was the president of the Harvard Crimson, the school's daily newspaper. During his time in Baltimore, he served for 10 years as the Atlantic magazine's Supreme Court correspondent and published more than 400 essays analyzing the Supreme Court's evolving jurisprudence and constitutional issues generally. He has authored books, among which are Democracy Reborn, the 14th Amendment, and the Fight for Equal Rights in Post-Civil War America, and American Epic, Reading the U.S. Constitution. His scholarship has been published in various law reviews, and he has authored numerous articles and editorials in the news media, and he has a very lively Twitter feed at Prof. Epps, P-R-O-F-E-P-P-S. And many of his presentations can be found on YouTube and other internet forums. The cases the U.S. Supreme Court has agreed to hear this coming term could have implications for state legislative authority over federal elections, affirmative action in college admissions, and the methods states use to draw legislative maps. It is no understatement to say that this could be another U.S. Supreme Court term of great consequence. We have 45 minutes for our session. I encourage you to please ask questions as we go along. And we will have, I believe, a traveling mic for that purpose. After the session, we'll have a 15-minute break before the final session. Please welcome Professor Epps now, and join me in doing that.
Thank you, Judge Acosta, for that generous introduction. And I want to say how delighted I am not just to be back at the law school where I learned my trade as a teacher, but at an O'Connell conference. I was the inaugural O'Connell faculty fellow many years ago and have been happily associated with the O'Connell program since then. I do want to say that if you are on the Supreme Court beat, as I was for 10 years, Fridays are a very nervous time. And those of you who've seen me looking at my phone, I was not actually tracking the baseball results, but the court has a habit of dropping orders at about 5 o'clock on Friday. The so-called long conference of the court took place on Wednesday. It's called the long conference because the court considers the petitions that have come in over the summer. And they announced the grants and the denials at some time after that. I thought it might be today, but it was not. Probably keep your eye peeled on Monday for some news about what cases, the new cases the court has granted. But the result is that today we have only good news and happy news from the Supreme Court, because today is the day Justice Ketanji Brown Jackson was formally invested by the court in a public ceremony as a new justice. This is traditionally a moment of good feeling among the justices and with the public, and it is probably the last of those for what promises to be a very contentious term for justices who are in a feisty mood. And some of you may have noticed the kind of dysfunctional family, passive-aggressive sniping that's gone for in sort of, well, tell Elena, if she thinks we're not legitimate, she's an idiot, And this indicates a real change inside the court. I think that relations are in a pretty testy state. I will say, first of all, that it is a great honor to me to speak to an audience made up of many judges, because you have to do the thing that I get paid to criticize and point out that you did it wrong. But that's the hard work, is deciding. That's what I learned as a judicial clerk, is I did all kinds of stuff in the library. It was awesome. And then the judge would say, what should we do? And I'm like, why are you asking me, right? So I hope that some of what I offer will be useful to you, though I warn you, so you can discount for ideology, that my last law review article was entitled "The Post-Trump Court, a brief inimicus curiae," right? Thus instituting a new form of action. Those of you who know Latin know that it means the enemy of the court brief. With that warning, I'm going to plunge in. I'm going to take a look at the marquee cases that are ahead. I will spend less time on the Brackeen case because you're going to hear about it in the next session. But people should feel free to ask questions. And once we get through the marquee cases, I may point out a few cases that will be of interest to people with specializations if we get that far. But as Judge Acosta said, please raise your hands as you go along. Now, just to set the table, I'm going to say that in my judgment, the October term, 21 to 22, was the most consequential term of the Supreme Court during the lifetime of anyone in this room. We are at what I consider to be, to use the term the Khmer Rouge government used, year zero. The Supreme Court has declared that all existing precedent is off the table, that existing methodology is off the table, that all the tests that I inflicted on my con law students, 3-part test and 2 parts of subpart 3, all off the table. We are in a new world, and it's very hard to know exactly what the court will do, though we do have a pretty good idea of the attitude of at least 5 and probably 6 of the justices. The first case that I want to talk about is called Merrill versus Miller, and this is a case out of Alabama that has to do with Section 2 of the Voting Rights Act. As you may be aware, the court 10 years ago basically did away with Section 5 of the Voting Rights Act, which was the most powerful civil rights tool that Congress has almost ever passed. They're now focusing on what's called the results test of Section 2, and that is that states cannot adopt measures, voting or measures that have to do with voting in elections, that have the effect of reducing the ability of minority groups to elect a candidate of their choice. And this comes out of Alabama. Interestingly enough, so did Shelby County come out of Alabama, and there's something, to my mind, because I grew up in the segregated South, there's something terribly odd to me about the idea that Alabama is suffering, these injuries from the Voting Rights Act. But the court is very sympathetic to the problems of Alabama. And the question was, given the percentage of black people, black voters in Alabama, shouldn't they have 2 of the state's, I'm going to say 7 districts as majority black districts? And the legislature of Alabama was very careful to make sure that didn't happen. They broke up some of the black communities into multiple other majority white districts, and so there's 1 majority black district in Alabama. This was challenged before a 3-judge panel, which hears, is the kind of body that hears redistricting cases, and 2 of the judges on that panel were appointees of the Trump administration. So this was not what I would call, a bunch of liberals. And that panel concluded that this was basically a violation of Section 2, that black people were being deprived of the level of influence the statute entitled them to, and they issued an order that for the 22 election, a different plan had to be adopted. You know, in relation to what was said on the last panel, the Supreme Court immediately issued a stay saying that even though, as a matter of law, they didn't reverse the lower court. They said even though, as a matter of law, this is a racist plan, you can use it for 2022. And I think that gives us a hint that something along the lines of Shelby County may be coming for Section 2. In this area, it's worth noting that, you know, I have done a lot of work and reading about the career of the Chief Justice, who in my mind is a very interesting figure. And the very first cause that he took up when he arrived in Washington after the election of Ronald Reagan as an assistant to Attorney General William French Smith was to fight the idea of Section 2 having an effects test. There are numerous memos written by this young lawyer, fresh out of Harvard Law School in a clerkship, you know, mocking the idea that the government should be concerned with whether minorities have these opportunities. All we have to do is, you know, stop overt discrimination and everything will be fine. And, you know, this is arguably the culmination of this particular crusade on his part. The court has already narrowed Section 2 in other ways in a case called Brnovich. And it's going to be interesting, as we see from the last panel, you know, one of the things the court has to do is figure out what Congress really wants when it passes a statute. And I think the record makes it, you know, utterly clear that Congress wants this effects test to be in place. Congress believes that the Voting Rights Act isn't achieving its full potential if Section 2 is only applied to intentional discrimination. And Congress has made it clear over the years that this is what it wants. And I think, you know, the chances are pretty good that the court is going to just find that Section 2 is unconstitutional. There will be very little left of the Voting Rights Act if that happens. And, you know, one of the narratives that this court the majority has used in this court is, yes, isn't it terrible how bad things were back then? Thank God everything's all right now, and we can forget all about this, which just the late Justice Ginsburg said akin to throwing away your umbrella in the middle of a storm because you're not getting wet as long as it's there. And so keep your eyes on that. The next test or marquee case involves two cases, one against Harvard and one against the University of North Carolina, called Students for Fair Admission versus Harvard, Students for Fair Admission versus University of North Carolina. And I want to take a minute to point out something that I think is really worth paying attention to from last term and this term, and that is how many of these cases, these agenda cases, which I call them, are being conducted by a relatively small number of extremely well-funded conservative groups. In other words, you know, the presentation of the Students for Fair Admission is they say, we represent 10,000 applicants to Harvard and 20,000 applicants to the University of North Carolina. In fact, you know, this Students for Fair Admission is an offspring of something called the Project for Fair Representation, which also finances major litigation against the Voting Rights Act, was responsible for funding the two cases about the University of Texas that came to the court, and is really the brainchild of a multimillionaire named Edward Blum, and who hires lawyers and has these things take place as if there's an upwelling, you know, of protest about this. Now, that's not to say that affirmative action is not controversial, that people feel there are winners and losers, there are constitutional questions that are raised by it. But, you know, it's instructive to see, you know, what the court grants. These cases were resolved by the lower courts in ways that, you know, suggest that the court granted cert in this case to reverse. And I certainly think that if you look at the careers and writings of the current majority, it's very hard to imagine that affirmative action that is defined as the use of race in college and university admissions as a plus in a so-called holistic admissions program. It's very hard to believe that this is going to survive. It had a near-death experience during the Texas case, the Fisher versus Texas, when an opinion was written saying, you know, we don't need these race-based, they violate, you know, Frederick Douglass would weep if he knew that we were doing this, using the rhetoric of the civil rights movement and the 14th Amendment to say that we must strike down any of these programs that seek to use race to include previously unrepresented groups. And they were poised to do that when Justice Sotomayor, who was then freshly on the court, wrote a dissent that was so brutal, I am calling you people out, you are racist dogs, that Justice Kennedy said, we can't do this. This is going to be too bad for the court. And they came up with this kind of weird compromise. I would call it a John Roberts compromise, but this was engineered by Kennedy, in which the test for affirmative action was tightened just a little bit. So, Justice Kennedy is gone. We don't have anyone on the court with that kind of desire to bridge the two sides. And I think that this is an agenda case. It is something that this court has this majority has been hankering to do for 10 or 12 years, and it's very hard to see how this succeeds. Now, the interesting question in this case, from an observer point of view, is that the claim going forward is that affirmative action using race as a criterion is that it discriminates against Asian Americans. And the argument is that Asian Americans come to the court with better credentials than everybody else, and they're discriminated against in order to make room for, basically the implication is, unqualified Latino, Black, other minority, Native American applicants. And I want to pause quickly to say this is a ghostly issue in these cases, is that, you just want to let unqualified people in. And, during one of the argument in one of the University of Texas cases, and I was in the room, the late Justice Scalia said, to the lawyer for the University of Texas, he had said, if you take away this program, our diversity will be reduced, and numbers of minority students will be reduced. And Justice Scalia said, well, I'm not really particularly worried about that. It will reduce the number of blacks at Texas. Maybe there are too many blacks at the University of Texas. And, there have been a couple of moments in that courtroom that were really dramatic, and this was one you could hear people all over the courtroom going, he said what? What did he say? And God bless the advocate who had been, Greg Garr had been Solicitor General for the second Bush administration and had the standing and the credibility with the justices to say, Justice Scalia, I don't think that the answer to the problems of separate but equal is to have a doctrine of separate but unequal. But that idea that minority students are unqualified is lurking in the background, and if you study the doctrine, you find that it's a canard. Nobody can be admitted under a constitutionally sound affirmative action program who isn't qualified. What has to happen after you determine the number of qualified applicants to any selective institution is which of that large pool you actually are going to admit. And the interesting thing about the Fisher case was that the plaintiff, Abigail Fisher, had to admit in the lower courts that the people she was complaining about, the minority students who'd been admitted instead of her, many of them had better grades and better scores than she did. But she said she was being injured by being forced to be part of any process that considered race. I think the practical implications of this are, pretty large. The states that have outlawed affirmative action have seen reductions in the levels of diversity at their state institutions. But I think probably we should get ready for that. There are no questions, right? Everybody is like understanding me perfectly, or that's impossible. Yeah. Nobody understands me, ever.
Just a very quick question, going back to the Voting Rights Act case that you mentioned in there, which I forgot. How does that relate to, as I understand the Supreme Court's decision several years ago, that it's not the place of the federal courts to take on the issue of gerrymandering? Sorry if that's an unimportant question, but I'm just trying to understand how
it's not an unimportant question, and there actually is a major case about that. But they didn't say that it was not the purview of federal courts to take on anything to do with gerrymandering, right? That would take us back to before Reynolds versus Sims and Baker versus Carr. What they said was the Constitution provides certain specific prohibitions. One of them is the 15th Amendment. And the courts must intervene in cases where there is intentional discrimination in redistricting, intentional racial discrimination, okay? Now, the case you referenced, which is Rucho versus Common Cause, was a case where the plaintiffs were asking the court to extend that principle to partisan gerrymandering. You have a state like Wisconsin or North Carolina where using powerful data techniques, the legislature is able to design a map of legislative districts that turn, let's say, a 45% vote for one party into 60% of the representation. That's done quite intentionally. In North Carolina, the plan that was challenged in that litigation, the Speaker of the House said, I think the state does better when we elect more Republicans, and we're going to try to make sure that happens. And the court said, we're not going to get involved in the partisan gerrymandering question because we can't think of a standard that would do anything except us taking sides in partisan struggles. Now, there's been a great deal of criticism of the intellectual honesty of that claim, but that is the difference. Race, it's still the case that the courts can intervene. And this is not a constitutional case, the one that's coming before the court now. It is a Voting Rights Act case, right? If you can prove intentional discrimination, you have proved a violation of the 14th and 15th Amendments. Section 2 of the Voting Rights Act goes further than that with the effects test and basically talks about this standard of opportunity, it's not a question of being entitled to a result, but a fair opportunity to elect candidates of your choice. And that would, if that is struck down, it would make it much harder to deal with, if you can believe, you can imagine anything like there was a state where there used to be segregation and there's still a lot of racism. Oh, yeah, wait, Alabama. And, it will make it much harder to challenge them under Section 2 of the Voting Rights Act.
And so, just following up briefly, what's the constitutional attack on Section 2 of the Voting Rights Act in this Alabama case?
Well, the constitutional background of this is that there's a series of decisions, beginning with a case called Austin City versus Namudno, in which the Chief Justice has expressed extreme discomfort with the use of racial statistical information in analyzing voting procedures. And he has got a very famous phrase that says, it is a sordid business, this divvying us up by race. And he has pressed forward with that. I honestly have trouble grasping the logic, and that's a limitation on my behalf. So I can't really give you a complete answer.
I'm going to give you the mic just so we make sure we catch the question. Yeah.
Excuse my potential complete ignorance here, because con law was not my strong suit in law school, but I do remember something about when you do not discover direct discriminatory intent, sometimes you can find it in what's called disparate impact, I believe. So how is this effects test not, the outcome of it could, particularly in some place like Alabama, be seen as fairly intentionally discriminatory in its outcome?
Well, it's a wonderful question, and you clearly, if you can remember disparate impact, you were awake in con law a lot more than you claim. But I will tell you to start by quoting an email I got from one of my con law students from the last spring semester that had the subject line, this deceptively happy subject line, saying, "I enjoyed your course, Professor." And I opened up the email, and it said in large letters, "But what the hell good did it do me?" And the answer is, none, except that you get to go on to be a 2L, because virtually all of this is being wiped out. And this court is quite hostile to disparate impact claims. And that is part of what's in the mix here. Is the effects test is like a heightened disparate impact standard. And the court basically would like to cut that, or the majority would like to cut that back to, you have to prove intentional discrimination, which is significantly harder to do. So your question is on point. Unfortunately, it doesn't get, unfortunately, what the hell good does it do us, right? So, but anyway, congratulations on staying awake. Anybody else? Yeah, in the back.
Judge Armstrong, yes.
The thing that strikes me about that whole issue that you speak of, both in the voting rights and the other cases, is that the Roberts effort is to advance this principle that the sordidness, that you just cannot, as a government, be interested in advancing on a racial basis any policy. And so if you have a principle in the Voting Rights Act that you, in terms of population, should be able to elect 2 black representatives, that alone is objectionable. As long as you're not intentionally trying to deny any political participation on the basis of race, that you're selecting the districts or in whatever way you're acting in order to diminish political power or the ability of people in a racial distinction to participate. That the converse, the ability to be politically effective in a way that considers race as a factor the government can focus on in order to advance that result is problematic. I mean, I think that's what it reduces to as well in the selection of students is, yeah, they're all qualified, but if you're trying to consider race as something you want to have achieve as a population or consideration, the government is disqualified from being allowed to do that under the Constitution. I think it's all wrong as policy. I mean, I'm not advancing that as good policy or a good understanding of the Constitution. I just think that's the way I've come to understand all of that, all the discussion about it, is to get the government out of trying to do anything that is racially sensitive, so long as it doesn't affirmatively try to affect in an adverse way people on a racial basis. And this idea of qualification, once you've established that these criteria are important, scores and so on, how do you then not reflect that or respect that once you start saying, but we want diversity as a policy where diversity isn't one of the criteria to make you eligible? There's a good answer to all that, but I think that's kind of what I've come to understand is the animating principle.
I will say a couple of things about that. The first is about one of the powerful challenges to affirmative action in this context is that they seeking a court ruling that diversity is no longer a compelling governmental interest. And if the court were to hold that, then no race consciousness would be acceptable at all because of strict scrutiny, right? But beyond that, I'll just say, as a matter of the attitudinal model, if you will, that of the things that John Roberts hates, affirmative action is probably number one. And you know, among other things, we found in the archives of the Reagan administration a speech that Reagan was set to deliver in which he was going to outlaw affirmative action in the federal government at all levels. And at the last minute, the Secretary of Labor came and said to him, do you have any idea what this is going to do to our work in the workplace? And Reagan backed off. But there's no name on that draft. But I know who was in the White House at the time, in the White House counsel's office, and it was John Roberts. So I think, you know, we're going there. But the other thing to understand is affirmative action is dying the death of 1,000 cuts. It has been ever since Bakke. And one of the points that's going to be brought up in this case is that when the Supreme Court upheld affirmative action in the Grutter and Gratz cases, Justice O'Connor put this oracular sentence in the opinion saying, we expect that in 25 years, this will no longer be needed. Well, we're at year 22, and there is nothing that Chief Justice Roberts likes more to say, oh, look how things have changed, we don't need this anymore. And I expect there will be some of that discussion. I'm going to go on to a case called Moore versus Harper, because as long as we're talking about votes and democracy, and this is the case, this is going to be very highly watched, about the so-called independent legislature theory. And that is the idea that the Constitution, which in two places has what are called legislative thereof clauses, gives to the legislature of the state and to the legislature alone the responsibility for conducting and setting rules for federal elections, either for members of Congress, that's in Article 1, or in choosing electors for the president. And this case has to do with the thereof clause in Article 1, the idea being that because this is a duty given by the U.S. Constitution solely to the legislature, state courts may not use their state statutes or constitution to strike down or question voting practices that are adopted by the legislature. If the legislature adopts redistricting plans, for example, state courts, for federal elections, state courts can't do anything about that. If the legislature adopts restrictive voting laws for federal elections, the legislature, the state courts can't do anything about that. State constitutions, which contain robust, many of them, protections for the right to vote, and in many states are interpreted by state courts to provide much more protection to the right to vote than is protected by federal statute. Those decisions would be off the books. The legislature could just say, we are in charge. Now, this has been represented as being a case about setting aside the results of an election and having the legislature choose the electors itself. That's not really at stake in this, and that is probably a far-fetched theory, though, you know, when I think of the court now, I'm reminded of a line from the poet Bertolt Brecht, who wrote, you know, of the situation before World War II in Germany and after it, who said, "The man who laughs has not yet heard the terrible news." And so I don't want to say that this won't get there. I'm quite sure that Justice Thomas would like to get there. It won't be in this case. But if the independent legislature theory is bought, that's where we're going. And I have been doing some work to try to figure out where this theory came from, because the truth of the matter is, the claim that it has deep historical roots is largely spurious, it seems to me. It comes from a separate opinion by then Justice Rehnquist in a case called Anderson versus Celebresi, who started saying, you know, you can't do this. You can't have all this states, courts meddling with elections because of the legislature thereof clause. It gets picked up in the Florida recount and is powerfully advanced by two friends that we are all familiar with. John Yoo, the professor at the University of Berkeley, who later went on to author the torture memos for the Bush administration, so that I think the logic of this is sort of tortured. The other who testified for it and advocated it in front of the state legislature was John C. Eastman, whom we are familiar with now as the potential defendant in an insurrection case. So, you know, there's something really eerie to me about this theory, which is being presented to an originalist court and has been adopted by several of the justices as an originalist position. I just don't think the evidence is there. And I do think it is something, you know, Madison said it is proper to take alarm at the first experiment upon our liberties, and I think this is an experiment upon free elections in the states. And I think it's something to worry about and keep your eye on, even though, you know, you will see in the press, you'll see it represented as a much broader case than it is. I don't like where it goes. I don't think it's a lock. I don't think this is like the fair representation cases. I don't think it's a lock that this court will adopt it. You know, I'm very much hoping that some of the practical problems that this will cause can be presented to the court in a way that will sway, and you know, there's no swing justices anymore, right? This court is a mirror of Congress. It has a Democratic caucus, which is in the minority in this case, and a Republican caucus, and they function precisely like legislative caucuses. But there is some possibility that one or two will cross on the grounds that the court has over many years expressed the desire not to inflict chaos on states that are conducting elections. And then the final case is something, I'll do this very quickly, called 303 Creative, which has to do with a state civil rights public accommodation statute that requires public accommodations, certain businesses doing business with the public, to serve all customers regardless of sexual orientation. And the plaintiff in this case is a website developer who creates websites for weddings. You know, Jane and Bob's wedding welcomes you. Click here to give them expensive gifts. Click here to see the ugly bridesmaid dresses. Click here to see the cake that you won't get any of. You know, and but this website designer says she is afraid, like there's no concrete dispute here, but she is afraid that this statute will be applied to her and that she will have to violate her religious principles by designing one of these tasteless portals for same-sex couples. And the court has, you know, said, yes, you're certainly injured. You can bring a pre-enforcement challenge, which is an interesting choice in and of itself. But what they also said when they granted cert was, we're not granting cert as a religion case. This is not a religion case. We're granting cert under the First Amendment free speech clause. And is this a situation where the state is compelling speech? And if it is, then, you know, none of these, I mean, you can't have racially restrictive laws, racial civil rights laws, if the people are engaged in expressive conduct. And lurking behind this is the issue of, well, who is engaged in expressive conduct? Who is an artist? You know, if a website designer is an artist, when this came up in the Masterpiece Cake Shop case a few years ago, Justice Kagan, you know, and this is why it's good to have men and women on the court, people of different backgrounds and stuff, because the lawyer for the cake baker was going on and on about how a cake is, you know, a work of art, and these cakes are, you know, masterpieces, hence the name. And Kagan says, well, what about a hairdresser? And I thought, you know, just from my own experience being married and so forth, I thought, that's right, you know, my wife thinks of her hairdresser as an artist, and where do we go with this, right? So the court is possibly opening up a can of worms, and it's possible that they'll find some way to turn aside this challenge. But once again, this is a case, an agenda case being brought by a very well-funded coalition of religious law firms like the Alliance Defending Freedom, the Beckett Foundation, and so forth. And the court pays very close attention to them. As you will see, and I'll end here by just saying the last thing the court has issued is a case called Yeshiva. It's an interim order in a case called Yeshiva University versus Yeshiva University Pride. And it was a case where a New York court said that Yeshiva University, a Jewish college, could not refuse to allow a Jewish pride group, a gay and lesbian group, to form on campus and conduct meetings the way any other student group could. And they applied to the Supreme Court to stay this, and interestingly enough, the court did not. The majority said, well, you haven't exhausted your remedies in the courts below, but there's a furious dissent by Justice Alito where he says, this court is telling a Jewish university what it may teach about the Torah, which is the way they see it. I mean, that's clearly wrong, I think, right? But that is the way they see it. That is the way these things get framed. And you probably have 3 votes to basically say there's something about gay and lesbian people that makes it okay to discriminate against them and makes it that the state can't protect them from discrimination in a way that racial categories and sexual categories do not have this defect. And it's, you know, troubling to think of how they'll enunciate that if they do, and it may be that the court will back off on the grounds that that's just a place we can't go. I don't know. We are, there's a full 2 minutes for another question.
We have
Those of you who are
time perhaps for one question.
regain consciousness.
Yeah.
Here. Can I give us?
I'm a very old constitutional lawyer,
Yeah.
a constitutional law student. I always consider stare decisis to be the linchpin of the American judicial system. If, in fact, that is abandoned, where is the stability for the system?
That's a wonderful question. I have, you know, summed up the doctrine of stare decisis that currently prevails at 1 First Street Northeast, and that is that stare decisis is powerful, it is important, it is binding, unless 5 justices of the current court don't agree with the case, in which case it goes. And, you know, I think of this court as having come unmoored. And, you know, cannons are sliding around on the decks precisely because there is no respect for stare decisis. And this is coming from a number of things. The intellectual author of it is Justice Thomas. And Justice Thomas is fascinating because he is convinced that since, in the 233 years since the founding, one person has understood the Constitution's original intent, and that's him. And, you know, if you look at his opinion in Dobbs, he wrote a separate opinion saying, yeah, we're going to overturn Obergefell. Of course we are. You know, it's a terrible opinion. If you look at his opinion in Dobbs, I counted this up. It has 29 case citations in it. It's a relatively short opinion. 15 of them are to his own opinions, which he cites as authoritative. They're dissents. They're written by one person. And I always say that Justice Thomas is the equivalent of Vicini in The Princess Bride, for those of you who have seen that movie, where the man in black says to him, you must be very intelligent. And Vicini says, let me put it this way. Aristotle, Socrates, Plato, morons. So, you know, stare decisis is in a lot of trouble. And what a judge is without stare decisis is something I can't really answer. We're done, right?
Yes, we are. Thank you, Professor Epps.